District of the State of Florida is now in session. The Honorable Scott Maycar, Judge presiding. All persons having business before this court draw near, give attention, you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
All right, good morning, everyone. Welcome to the 5th District Court of Appeal. We have two cases on our docket this morning. We'll hear argument first in case 24-0369, Clay County Port versus City of Green Cove Springs et al. Counsel, are you prepared? All right, you may approach. And would you like to reserve any time for rebuttal?
Yes, Your Honor. 5 minutes, please. Good morning, Your Honors, and may it please the Court. My name is Tom Schulte, and I'm here on behalf of the appellant, Clay County Port Incorporated, which I'll refer to today as Clayport. Your Honors, this appeal arises from a consistency challenge under Florida Statute Section 163.3215, where Clayport challenged the consistency of a rezoning order that would allow the Hall appellees to build an apartment complex in close proximity to the airport that Clayport owns in Clay County, Florida. But the crucial issue in this appeal relates more to Chapter 333 of the Florida statutes, which is Florida's airport zoning law. And if it pleases the court, I'll spend most of my time today focused on Chapter 333. The trial court refused to consider evidence of how Chapter 333 affected the rezoning order's consistency with the city's comprehensive plan because the trial court deemed Chapter 333 irrelevant to the consistency analysis.
Counsel, that ruling occurred at the end of the trial, and during the course of this bench trial, is there any evidence that the trial judge prohibited from being entered or blocked from being entered as it would concern the application of Chapter 333 to the facts of this case?
Your Honor, no, there was no evidence that the trial court precluded from being entered into the record. But in the final judgment at page 2799 of the record, the trial court stated that it deemed Chapter 333 irrelevant to the consistency analysis. And then it continued to go on into the consistency analysis without actually undertaking an analysis of how Chapter 333 might play in. And that's
the standard of review in this case. It's an abuse of discretion, correct?
Your Honor, the evidentiary ruling is an abuse of discretion review. But as I believe the appellees pointed out in their brief, the trial court's interpretation of Chapter 333 and how it applies to a consistency challenge under Section 163.3215 is a de novo review because it's the interpretation of a statute, and the consistency statute also requires a de novo review in a consistency challenge such as this one. Your Honors, reversal is appropriate here for two reasons. First, Chapter 333 is relevant under the explicit terms of the city's comprehensive plan. And second, Chapter 333 applies to private airports, including the airport that Clayport owns, which is being impacted by the rezoning order at issue in this appeal. To my first point, Chapter 333 is relevant under the explicit terms of the comprehensive plan. And that's most clearly shown where the comprehensive plan states that a property owner's right to use, develop, and improve their property is, quote, subject to state law, and that's at Record Site 2461. So by referencing state law, this comprehensive plan explicitly requires the city, and thereby any reviewing court, to consider applicable state law when determining whether a development order is inconsistent with the comprehensive plan. But here, as I said before, the trial court disregarded Chapter 333 entirely in its ultimate analysis of the consistency challenge. It found that, as I said, the trial court found Chapter 333 irrelevant and essentially dispensed with any sort of analysis under 333 as it undertook the consistency analysis under 163.3215.
Did any of the witnesses unequivocally testify that 333 applies to this private airport in this application?
Yes, Your Honor. Our expert witness, Clayport and Pegasus's joint expert witness on aviation, testified that 333 would apply in this scenario because it would apply to private airports. And
Are you referring to witness Halesko, is that correct?
yes, Your Honor.
Okay, didn't witness Halesko, and I'm going to the transcript, page 172 to 173, he stated on cross-examination that 333 only applied to public airports. Is that correct?
Your Honor, if I remember correctly, I believe he had stated that in a prior report that he issued, and that report, which we colloquially referred to, was the Passero report, which was entered into evidence. I believe in that Passero report, Mr. Halesko stated that Chapter 333 applied to public airports. But at trial, Mr. Halesko's testimony related to the fact that Chapter 333 could apply to the private, public, and military airports in the state of Florida, and that the city was required to undertake a consideration of whether there were airport protection or any airport hazards in need of airport protection zoning regulations. Your Honors, considering this consistency plans, the comprehensive plans reference to state law, it's important to consider how Chapter 333 might affect the rezoning order at issue here and whether it's consistent with the comprehensive plan. And several provisions of Chapter 333 bear on this issue. First, Section 333.03, subsection 1A, states that the city must adopt airport protection zoning regulations to regulate airport hazards that exist within the city's territorial limits. And at trial, Clayport offered evidence that the apartment complex contemplated by the rezoning order at issue here could create a hazardous condition and interfere with the safe use of the airport's airspace. And sticking with this theme of safety, Section 333.02 states that airport hazards are a nuisance because they endanger the lives and property of those near the airport. And this theme of safety is important because if the rezoning order poses a safety concern, as provisions of Chapter 333 suggest that it does, that safety concern is certainly relevant to whether the rezoning order is consistent with the comprehensive plan, because the comprehensive plan at its core is intended to further the welfare of the city's residents.
Was safety not considered at all by the lower tribunal?
Your Honor, I don't believe from the lower tribunal the trial court considered safety in terms of Chapter 333.
I mean, just in the overall proceeding, was there any evidence brought in or testimony or documents, whatever, that talked about this is going to be unsafe?
Yes, Your Honor, there was evidence submitted by Clayport and the trial transcript from page 163 to 164. Mr. Halesko testifies that there would be noise and safety concerns with where the apartment complex was situated in terms of where the flight path of the airport was. And in the process of the city adopting the rezoning order before the litigation was initiated, Clayport and our co-plaintiff Pegasus had several times reiterated their concerns that the apartment complex would pose a safety concern.
Well, what I'm getting at to some extent is, okay, the trial judge said I'm not going to consider this statute, but is there sufficient evidence in the record here to support that the issue of airport safety and how this structure might affect it was discussed and formed a basis of the consistency determination?
Your Honor, I don't believe there is sufficient evidence that I don't believe I'm understanding your Honor's question.
Put the Chapter 333 aside, okay? On the record of this case, was there testimony or evidence about airport safety and how this structure, this apartment would affect it, considered by the trial court?
Your Honor, I don't believe... Your Honor, yes, there was testimony by Clayport and Pegasus's expert that this airport would pose a safety concern, and as well as concerns for the noise of the for those that are living in the apartment complex.
Because what I hear your argument to be, hey, the trial judge ignored this statute, it deals with airport safety and the structures around it, and therefore, if he had considered it, then we would have a different outcome because he would have had to consider safety. And then my initial question was essentially, wasn't it really considered in the record here anyway? And you're saying kind of, but not, I think.
Your Honor, I'm saying that safety was not sufficiently considered in this trial proceeding, and it wasn't sufficiently considered by the city when it adopted the rezoning order, because Section 333.031A requires the city to consider whether there's an airport hazard created by the rezoning order or any sort of development in their territorial limits. And then if the answer to that is yes, to adopt airport protection zoning regulations to regulate that airport hazard. But here, and the trial transcript bears this out, the city did not consider the requirements of Section 333.031A. And rather, the only real reference that the city made to Chapter 333 was an acknowledgement that other sections of 333 require a public use airport to adopt an airport master plan. And then after acknowledging that, the city essentially said that because this isn't a public use airport, there's no need for an airport master plan.
Counsel, as a follow-up to Judge Makar's question, correct me if I'm wrong, or is this another case? I don't think so, but there was a buffer between the proposed development, which was a 59-foot structure, and the runway, or the end of the runway, and that was outside the runway protection zone. I believe the trees were in excess of twice the height of the proposed structure. Was there any testimony received, or was there any position taken by your client in front of the trial court that that height and that buffer zone created any sort of safety concern, or hadn't created any safety concern leading up to the point of the trial?
Your Honor, in terms of the buffer being large enough to be outside the runway protection zone, that's correct. The trial record does bear that out. The important point of Section 333.031A is that although the Chapter 333 generally speaks in terms of federal and state metrics for airport zoning, that's not all that the city could consider when undertaking a consideration of airport protection zoning regulations. And here, the city could have, and from our position, should have considered the fact that the apartment complex in the 59-foot tower, even if it didn't violate any sort of federal or state zoning regulation, that it might still nonetheless pose a safety concern. And that's the evidence that Clayport introduced at trial that ultimately the trial court disregarded, was that these apartment complexes could pose a safety concern, notwithstanding the fact that federal and state airport metrics didn't conclusively establish that.
As far as the application of Chapter 333, the trial court also received testimony from Mr. Daniels as far as a conversation that took place between Mr. Daniels on behalf of the city and Department of Transportation, correct?
Yes, Your Honor.
And your client did not challenge that. Obviously, your client, I think the testimony was not a part of that meeting, but yet requested that the city undertake that meeting. But where was the substance of the information received, that being that FDOT didn't believe that 333 applied in this particular scenario? Was that challenged at all in front of the trial court?
The trial court's receipt of that testimony, I believe there was a halfway challenge to it in the fact that we didn't challenge the fact that Mr. Daniels had that conversation and that Clayport had requested Mr. Daniels have that conversation. And we didn't challenge the fact that Mr. Daniels testified as to what his conclusion was at the result of that conversation, but I don't believe there was any entry of Mr. Daniels repeating what was said to him by the Florida Department of Transportation. And on that point, Your Honors, it's important to consider that although the Florida Department of Transportation weighed in on this issue, they are not the governing authority as to the applicability of Chapter 333 to a private airport. And the governing authority on that point is the text of the statute itself. And that leads me to the second point of my arguments, which is that Chapter 333 applies to private airports. It applies by the explicit text, and that's shown in several different references to where the legislature will refer to an airport generally in one section, and then in another section will refer to a specific type of airport.
Counsel, doesn't 333.13 give political subdivisions and FDOT the right to enforce violations of Chapter 333?
Yes, Your Honor. And the DOT is not without any sort of power or relevance, for lack of better words, with Chapter 333. But the DOT can't make the decision that 333 just categorically does not apply to private airports when the statute's text shows that certain sections do. Certainly, some sections do not apply to private airports. But critically, Section 333.031A refers to airports generally. But then if we look to other sections of the chapter, for example, Section 333.01, subsection 15, it's clear that the legislature knows how to differentiate between types of airports that it intends to be covered by a statutory section. Because in subsection 15 of Section 333.01, the legislature defines public use airport. And then again, in Section 333.03, subsection 1B, the legislature limits the applicability of that subsection to airports owned or controlled by a political subdivision. And so if the court looks to subsection 1A, the legislature refers to airports broadly. But then in subsection 1B, there's a reference to airports owned or controlled by a political subdivision. And so it's clear that the legislature intended subsection 1A to apply to airports broadly, and the airport protection zoning regulations of that section were to be applied to airports broadly. Your Honors, to conclude here, Chapter 333 is relevant under the explicit terms of the city's comprehensive plan, where the comprehensive plan references state law that the city must consider when engaging in local decision-making. The trial court thus erred by refusing to consider Chapter 333, and this error was harmful because if the trial court had considered Chapter 333, it likely would have found that the residential towers in the flight path of the airport were inconsistent with Section 333.03's directive to adopt airport protection zoning regulations, which the city did not adopt in this case, and which the city did not even consider to adopt. In other words, the rezoning order would pose a problem of being inconsistent with state law, which would not be appropriate under any reasonable interpretation of the comprehensive plan. And so Clayport asks that this court vacate the final judgment and remand with instructions for the trial court to conduct additional proceedings as necessary to consider the effect of Chapter 333. Thank you.
Thank you, counsel.
May it please the court, my name is Wayne Flowers, and along with my co-counsel Brenda Durden, who's in the audience here, we represent the city of Green Cove Springs. The city and the Hall family parties have agreed to equally divide the Epley's 20-minute time for argument. I'll take 10 minutes for the city, and Christy Russell, who is at the table with me, will take 10 minutes for the Hall family parties. The Appleys are asking the court to affirm the final judgment entered below, and my argument will focus on the city's comprehensive plan, particularly the relevant provisions in issue here, and how those provisions should inform the court regarding this consistency analysis. Importantly, most of Judge Lester's determinations and findings regarding consistency have not been appealed here and are not an issue here. And in fact, as we've already discussed, the only issues that are left for review here are Judge Lester's determinations that Chapter 333 Florida statutes is not relevant to the consistency determination in this case, and that even if relevant, no evidence was presented showing that under existing conditions that the PUD as conditioned would violate relevant federal hazard or noise regulatory standards which are incorporated in Chapter 333, facts even Clayport's expert did not contest or disagree with. Ms. Russell will focus on the appropriate scope of a consistency challenge and the evidence that was appropriate for use by the city and the lower court in determining consistency of the PUD with the city's comp plan, including Chapter 333. Green Cove Springs, for those of you who don't know, is a small but growing city in Clay County on the banks of the St. Johns River. And like many small Florida cities, it seeks to develop its economy, which includes providing for needed housing stock, particularly multifamily housing, in a manner that is both orderly and reasonable through its comprehensive plan. There's a few important points that the appellees think is very important to make here at the outset of this argument that are critical and we believe undisputed. The first is that Clay County Port, Inc., I'll refer to them as Clayport, is a private Virginia corporation. It is a private entity landowner. They're not an entity of government, and they're no way associated with any entity of government. Second, this is the third of three legal challenges initiated regarding the rezoning of the Hall property. The first was a petition for administrative hearing before the State Division of Administrative Hearings, or DOA, that was brought by Clayport's tenant, Pegasus Technologies, Inc., I'll refer to them as Pegasus, brought pursuant to Section 163.3187, which provides the cause of action for contesting the consistency of a small-scale comprehensive plan amendment with the Growth Management Act, which is Chapter 163. The petition filed in that case by Pegasus alleged non-consistency based on state law compliance issues, including most of the same Chapter 333 issues that have been raised now by Clayport. Clayport didn't join in that action, and it was voluntarily dismissed by Pegasus the very day before the administrative hearing was to commence, after extensive discovery. But because the petition was dismissed, the future land use map designation of the Hall property as mixed use became final and can no longer be contested. The second action initiated by Pegasus that wasn't joined by Clayport was a petition for writ of certiorari, contending based on the record before the City Council that the approval of the PUD rezoning departed from the essential requirements of law. Among other contentions, the claimed departure was the city's failure to comply with Chapter 333. A final order was entered by Judge Lester upholding the rezoning and making specific findings regarding the applicability of Chapter 333 to the rezoning, which have not been appealed and therefore are final as well.
Counsel, do you believe, are you interpreting the sentence in Judge Lester's order, however, even if applicable to a Section 163.3215 challenge, no evidence was offered at trial that the PUD rezoning violates any such standards, Record 1503 to 1504, is that evidence that Judge Lester considered the requirements of 333 and found that there was no violation, or even if it was applied, there would be no violation based upon the record evidence and testimony that was received at the bench trial?
Yes, Judge Wallace, I believe he explicitly did that. As you've noted already, there was extensive testimony concerning the two metrics that are in Chapter 333 that are incorporated from Part 77 of the federal regulations that deal with both noise and obstructions. And the testimony was offered, and Judge Lester explicitly found that those standards, there was no evidence to show that those standards were violated.
Well, but Judge Lester also, I guess, made note that there was an offer or there was an order that part of the lease agreements between the individuals that would lease units of the development would then be advised of the potential of a noise problem or noise nuisance. Isn't that correct?
That is correct, Judge Wallace. And again, as we discussed earlier, the executive director and the airport expert for Clayport asked for two things prior to the City Council's approval. One was that they contact DOT, discuss with them any requirements DOT may require related to the airport being there, and that they put a condition regarding a notice to potential lessees of those apartments that there's an airport there and there could be a noise issue. And they did both of those things. So you are correct. That was addressed in the order and was addressed, it was noted in the order and was addressed in the City Council's conditions related to the PUD. The other, again, getting on to the other 2 points that I wanted to make, there were no Chapter 333 issues actually pled in the complaint in the case. And the final point is that the evidence from both parties' experts, as we've noted, their expert agreed that the runway is configured and the development is conditioned meets both of the metrics that exist in law in Chapter 333 for public use airports for height obstructions and noise. And if we need to, we can talk about those metrics, but I don't think there was any dispute. And arguably the only issue that Clayport raises, and they kind of raise it obliquely, is, well, if we wanted to extend this runway to 7,500 feet at some future time, there might be a problem. But of course, there's no present plans for that to happen. They've looked at it several times over the last 40 years and each time decided not to do that. So if I could talk about what we feel are the relevant portions of the comp plan, the mixed-use future land use designation for the Hall property isn't in dispute, as we've said. It specifically says that new development activities will be directed in the appropriate areas of the city as depicted in the future land use map. By virtue of the comp plan amendment, which is, was not contested, contesting was dropped at the last minute, the mixed-use land development designates and authorizes multifamily uses on the Hall property. So in terms of the compatibility issue, in general terms, it is consistent, certainly with the language in the comprehensive plan, because mixed use is designated on the comp plan as appropriate for this property. And so in terms of, there are arguments made in compatibility and specific findings and extensive testimony in the record about compatibility of mixed use and multifamily on this particular, the Hall property in the final judgment. So the other thing I want to mention is in terms of the comp plan, is the mixed-use rentals park, or the MERP designation for the property owned by Clayport, which was initiated, that designation, that whole MERP designation on the future land use map was initiated by Clayport in 2009. And there are a variety of uses described in Objective 1.7 of the comp plan, and the policies 1.7.1 through 1.7.8 permits a wide variety of uses that includes residential. In fact, it indicates there should be a minimum residential use of 20%, maximum residential use of 65%, with densities even greater than what is allowed through the PUD on the Hall property. There's a character area indicated in there for aviation industries, which are to be combined with multifamily residential opportunities. They argue, in their brief at least, that this recognition of aviation industries, again, somehow bootstraps Chapter 333 into the consistency analysis. I would suggest that it doesn't. My 10 minutes, I believe, is up, so I'm now going to yield to Ms. Russell.
May it please the court. Christy Russell on behalf of the Halls, who are the property applicants and owners and who intervened as defendants in this action below. And also here with me today is my partner, T.R. Hainline, who was trial counsel in this case. The court should affirm the trial court's decision for two reasons. The first is the trial court correctly determined that Chapter 333 was not relevant in this comprehensive plan consistency challenge. Second, the trial court correctly determined that even if Chapter 333 were relevant, there was no evidence put forth by the plaintiffs in the case that there was any violation of any federal or state administrative standard. This case is...
Counsel, why doesn't the simple reading of Policy 10.1.1b, the rights of a property owner to use, maintain, develop, and improve his or her property for personal use or for the use of any other person shall be subject to state law and local ordinances. Why doesn't a plain reading of that language and its reference to state law incorporate a consideration of Chapter 333?
Well, in order to read it that way, Your Honor, it would have to be read to incorporate any state law into the comprehensive plan. And the language that Your Honor is reading from is proposed form language set forth in Chapter 163, 3177 for use in a local government's private property element. I think the plain reading of that is that it talks about the scope of the private property owner's rights. In other words, the local government has to take those rights into account, but of course they're subject to state law. I don't think that provision can reasonably read as implementing state law generally. In order to do that, the local government would be turned into an enforcement mechanism, essentially assuring that state law is complied with. In this particular instance, Chapter 333's enforcement is left to the Florida Department of Transportation, not to local governments. And so to read it the way Clayport is suggesting would be to essentially incorporate every state law into the comprehensive plan.
So your position is that that phrase should be used as a right to your clients, but not as a limitation to what your clients want to do on the property, as opposed to it's a limitation to the appellant's rights in this particular course of action.
I think it acts as a limitation if a property owner wants to do something that would be contrary to state law, Your Honor. But in this case, the comprehensive plan doesn't make any reference to Chapter 333 or airports or runways at all. The comprehensive plan doesn't speak to that. And so to read it the way the plaintiffs would want it read would mean that one thing that we've struggled with is what exactly was the trial court to determine was inconsistent with the comprehensive plan. The Hall's property was designated through a comprehensive plan amendment as mixed use. And most of the trial, the majority of the trial, was addressed to whether or not the rezoning was compatible and appropriate in a mixed-use land use category. So the question becomes, what was the trial court to determine was actually inconsistent? Was it to incorporate and look to Chapter 333? Was it to have determined that the city was to stop its consideration of the zoning regulation, the rezoning application, adopt regulations under Chapter 333, incorporate those into the comprehensive plan, and then determine that there was some inconsistency? The focus of a Chapter 163, 3215 proceeding is on the consistency of the development order with the comprehensive plan. To read that provision would basically put a burden on the trial court to determine consistency not just with the comprehensive plan, but with any state law that a challenger would say needs to be incorporated. And I think it's very relevant here that the appropriate place to challenge the mixed-use land use category change that was done through the comprehensive plan amendment would have been an administrative proceeding with the Department of Administrative Hearings. And any affected individual can file that. In fact, Clayport's tenant did file that action. In that type of action, the administrative law judge is empowered to look at whether or not the local government's proposed comprehensive plan amendment here, changing the category to a mixed use, complies with state law, including Chapter 333. That proceeding was dismissed by Clayport's tenant Pegasus the day before the hearing, and this evidence was all teed up for the administrative law judge to hear. And Clayport itself never filed that type of administrative proceeding. That would be the proper forum for that kind of consideration. The other type of forum that would be appropriate might be some kind of action asking FDOT to enforce Chapter 333 if there was some question that the city had not done what it was supposed to. And again, that's not this type of proceeding. The other type of thing that might have been possible was to raise that as part of a petition for writ of certiorari. The trial court denied Clayport's petition for writ of certiorari, and the standard there is there a departure from the essential requirements of the law? Clayport did not seek further review of the trial court's denial of the petition for writ of certiorari. So I think there are appropriate places where that issue can be raised. I mean, our position would have been in the administrative challenge. Chapter 333 is not relevant to private airports, but the issue was teed up to be heard there, and that makes sense because the Department of Administrative Hearings is going to be charged with applying that state law and making sure that comprehensive plan amendments are in compliance. Here, the comprehensive plan is what the trial court is looking at. Is the development order consistent with the comprehensive plan? The reading that's being proposed by Clayport would be, well, you incorporate essentially any state law, and you charge the trial court with looking at whether or not this proposed development order complies with state law. That is clearly outside the scope of what the legislature intended. It's a very limited statutorily created remedy, and the trial court is to look at the development order and the comprehensive plan. The court inquired as to whether or not there was testimony by Mr. Halesko as to whether or not Chapter 333 applies to private airports. I think Mr. Halesko did agree that it does not, with our position that it does not apply to private airports. Starting at page 173 of the trial transcript of the record, Mr. Flowers was cross-examining Mr. Halesko, and he says at line 14, "Yes, sir, you concluded there," and he's talking about a report that was prepared for this property, "you concluded there that Reynolds Park was not included in Clay County's zoning regulations because the airport is privately owned, private use airport. Is that right?" Answer, yes. He goes on in his cross-examination on page 174 of the trial transcript record. "So the tie between having to establish the ordinance, at least based on what you say there, is with becoming a public use entity." Answer, yes. Page 175, Mr. Flowers was talking about a PowerPoint that was distributed. That is an exhibit, it's actually Defense Exhibit 1 in the record on appeal. He's talking about 2 bullet points. And the question is, so again, 2 bullet points that were in the PowerPoint. One of them was Clayport private equals no height zoning regulations. Bullet 4, Clayport public equals height zoning regulations will need to be established in Green Cove. And the question then, so again, you are equating the need for or the adoption of airport zoning regulations with the airport becoming a public use airport. Answer, yes, and that's on page 175 of the record. The other portion of the record that I think is critical is Mr. Halesko's testimony at pages 181 and 182 of the record, where Mr. Flowers cross-examined him on the applicable federal and state standards and whether he felt that there was any violation of either a noise metric or an obstruction metric. Would the 59-foot buildings constitute an obstruction under federal law as incorporated through Chapter 333? And Mr. Flowers' question on page 182. And I think you agree that in the current configuration, both of those metrics are met, both the height metric and the obstruction metric and the noise metric. Answer, yes. So I think that, again, the trial court was entirely correct that Chapter 333 was not relevant in this consistency proceeding.
I could ask a quick question. 333.031A, which deals with every political subdivision shall adopt zoning regulations. How the city hasn't adopted any regulations, correct? Okay, so they take the position that this doesn't apply to them.
Correct.
So assuming it did apply to them, how would someone go about forcing them to have regulations consistent with that provision?
I think perhaps you'd have to ask FDOT to enforce those. I think the opportunity to make that argument has passed because nothing was filed at the comprehensive plan stage when it could have been filed with DOA.
Because if I'm the trial judge in this case, I say, okay, well, yeah, it says they're supposed to have regulations. They don't have regulations. What am I to do with that? I'm just here on the consistency thing. That's your point, which is this is a different animal than...
Yes, Your Honor.
Right, so...
I think a petition for writ of mandamus, perhaps asking FDOT to take action if required.
If you want to take a moment just to conclude.
Yep, thank you, Your Honor. So the trial court's decision was correct, both as a matter of law because Chapter 333 does not apply, and because the trial court correctly determined that even if it did, there were no violations of any applicable standards. For those reasons, we respectfully request that the court affirm the final judgment below.
Okay, thank you. If the marshal would add 24 seconds to appellant's time. Thank you.
May it please the court. Your Honor, to address what Ms. Russell was addressing right before she sat down of sort of what is the trial court to do, that illustrates why a remand here is appropriate, because on remand, this court could instruct the trial court, as we asked for, to conduct such additional proceedings as necessary. And so what does that look like? For us, Your Honor, for Clayport, an appropriate option would be for the trial court to instruct the city to actually undertake that analysis under Chapter 333 and determine whether airport protection zoning regulations are needed. Not because this is a bootstrapped 333 action, but because, as Judge Wallace pointed out, the comprehensive plan requires the use, development, and improvement of a property owner's property to be subject to state law, which inherently requires a consideration of that applicable state law. And on that point, it's not, as the appellees sort of stress, it's not every state law on the books, right? The city doesn't have to sit down and read every statute.
I'm sorry to interrupt, but I'll keep your thought, but I'm struggling because 031A talks about the entity, political subdivision, shall adopt regulations. Okay. I mean, that's a whole different issue here. I think you're saying is that this proceeding below should have considered, if there were regulations, whether this project, this PUD, whatever, complied with those regulations. But there aren't any regulations. So I'm not sure, it's kind of circular that.
Your Honor, respectfully, that's not our position. Our position is that the city should have undertaken the analysis in the first place. And perhaps they reach a conclusion that says we considered Chapter 333, specifically the airport protection zoning requirements under subsection.
But is there a uniform set of airport regulations out there that the city should adopt?
No, Your Honor, there's no uniform set of zoning regulations. And that's why it's critical here for the city to at least undertake the analysis because, and we introduced this in the post-trial motion.
But they can't because they don't have regulations. They can't apply the regulations here because they don't have any.
The consideration would be to whether to adopt any airport protection zoning regulations in light of the fact that there's going to be a 59-foot apartment complex in the flight path of the airport. And Your Honors, to a point that both Mr. Flowers and Ms. Russell made, is they emphasize that no federal violation has happened here. But I want to reiterate, that's not the only thing that the city could or should consider when undertaking whether to adopt airport zoning regulations.
Could or should really isn't relevant, is it? It's
Sorry?
what are they compelled to adopt? It's not what they could adopt, what they should adopt. It's what are they compelled to adopt?
Correct, Your Honor, and that's not what Clayport's action is challenging, is that they should have adopted any specific airport protection zoning.
Just more.
It's just some, Your Honor, is that they should have at least considered it, and from our perspective, they should have adopted some.
Seems pretty abstract when you have the burden of showing that they weren't in compliance.
Your Honor, our burden here goes to the comprehensive plan and showing that there is an inconsistency in the comprehensive plan. And to, I guess, make a quick point of clarification here, the court's review in a consistency challenge of a comprehensive plan is de novo, and it applies a strict scrutiny review, which actually places the burden on the city, the local government, to show consistency of the rezoning order. And that's where the burden is important here, because this is not an action under Chapter 333, despite the appellees trying to paint it that way. This is an action where Clayport is challenging the rezoning order that allows an apartment complex to be built in the flight path of an airport that's being active in the state of Florida. And as Judge Wallace pointed out, the comprehensive plan specifically requires the city, when engaging in local decision-making, such as rezoning, to consider applicable state law, is that the development order and the development rights issued by the rezoning order must be subject to state law. But here the the city, and thereby the trial court, didn't consider any of the applicable state law. And that's why we're arguing for a reversal here and a remand to instruct the trial court to conduct additional proceedings as necessary to allow the city to consider what might be required under Chapter 333. Thank you, Your Honor.
Thank you, counsel.